The presidency says it'll seek constitutional guidance after the Western Cape High Court ruled that President Cyril Ramaphosa's decision to suspend Busisiwe Mkhwebane as public protector is invalid. So in case you missed it, the court says there's reasonable perception that Ramaphosa was not impartial when it came to that suspension because of Mkhwebane's investigation into the 2020 robbery at Ramaphosa's Phala Phala farm. Now, earlier this year, you'll remember the public protector asked the president to respond to 31 questions surrounding the saga. The High Court has also seemed to take exception to Ramaphosa's decision to suspend Mkhwebane a day before the court ruled on an urgent bid to block him from doing so. The obvious question, what implications does this ruling now have? Let's get you some analysis now. Bring in legal analyst Mpumelelo Zikalala, who's, of course, no stranger to us here on Newzroom Afrika. Great to see you, sir. Thanks once again for making time to speak to us. This ruling has been described in some instances as a major political blow. I mean, do you reckon it clears the path for Mkhwebane to get back to work?
It does, depending on how you choose to interpret. From the side of Advocate Mkhwebane, she will say, the court has given me the green light. It has said that my suspension was clearly irrational and not in line with the Constitution. So I can go back to work and fulfill my duties as usual. However, from the side of the president, maybe they will seek a legal advice and then come back with an opinion of saying, yes, it may have done so. However, because it's ruled on the conduct in which you have exercised your particular powers, the Constitution in terms of Section 172 is clear as to how that should be confirmed by a constitutional court or the constitutional court. So it clearly depends on whether the application was brought in terms of Section 1721 or 1712. But nonetheless, I think this matter is going to go back to court for sake of clarity so that everyone is clear as to where they stand in all this particular matter. The president may even choose to come and say, I'm going to appeal this particular matter to the Supreme Court of Appeals. Once I've launched my appeal, it means it suspends the order which was given out yesterday, and the status quo or the status quo as of yesterday would simply resume.
Okay, that was going to be my next question, because my understanding is that, in fact, the DA has already lodged an appeal of this particular ruling. Does that suspend the effectiveness of this ruling? In other words, do we reckon that nothing changes from yesterday to today until, something has been said about the appeal itself?
Yes, if the appeal has been lodged, then it does suspend it. There are exceptions to the rules, though, in terms of saying the application can be brought, or depending on the nature of the order which was given yesterday, it may grant interim relief. On my reading of it, it did not grant any interim relief. It would be purely up to the parties. But if an appeal has been launched, it simply means go back to the status quo. It's as if the judgment was not issued at all, and what the state of circumstances before will still remain up until this particular appeal has been dispensed.
Yeah. Let's talk a bit more about, this clause of the Constitution, Section 172 that you've already spoken about, which essentially, in layman's terms, says if the High Court rules that there's any constitutional invalidity involving the conduct of the president, that ruling needs to be confirmed first by the Constitutional Court before it can be effective. What's the thinking behind that?
It must be put into context, though. Maybe let's take 172 in its entirety.
Sure.
1721 firstly said any court which is dealing with a constitutional matter, in which, in a basic understanding, it would mean the High Court or the Crown Court. Once it has taken its decision that any law is inconsistent or the conduct is inconsistent with the Constitution, it has to issue out an order of saying, yes, I want to limit the respectivity of that particular order or the action that has taken place, suspending or an order suspending the invalidity, or try to find ways of curing the incompetence or the defect that it has found. But now, 172 then goes further and specifically zooms into the Supreme Court of Appeals, to the High Court or any court which of a similar nature. That could be the Electoral Court, for example. And then it says to them, we are giving you specific powers of saying, once you have declared a certain act or conduct or invalid due to be in contravention with the Constitution, it must be confirmed by the Court first before it is taken as that really that particular conduct has been inconsistent with the Constitution. Now, it would depend on the type of interpretation that you want to adopt. The first one being that if I've made an application as per Section 72(1), once I've got my order, I do not need this particular confirmation. However, if an application is made as per Section 172(2), yes, then I do need that particular confirmation. But where maybe rationality would then come in, it would mean that one may assume that 172.1 was specifically for all courts, but exclusively or in line more for the Constitutional Court rather than the other courts. Why would the legislature see the need of emphasizing the Supreme Court of Appeals, the High Court, or any other similar court, if Section 72.1 will be able to cover the instances in which all these particular instances are going to be taken care of? So it may be a difference on this type of interpretation, but the normal rules is that once the Supreme Court of Appeals, the High Court, or a court which is similar to that, has pronounced on the constitutionality of a conduct of the president, is even specific, or an act of legislation which is promulgated provincially or nationally, then the court must confirm that particular decision.
Fascinating and complex in some instances. Let's dive deeper into it. And by the way, for the benefit of our viewers, we're showing live visuals of the actual sitting itself, this impeachment inquiry looking into Busisiwe Mkhwebane's fitness to hold office, as we have our discussion. But part of what some people say is at the center of this ruling from the High Court is that there's a question of whether or not the president was impartial in handing down the suspension to Busisiwe Mkhwebane. Some of your colleagues, other legal analysts, raising questions around whether or not we can apply the reasonable apprehension of bias against the president, given that he's not a jurist, he's not a judge. What's your take on that? You can't ignore it at the end of the day, because if you look at the Constitution, Section 33 will tell you that in order for any decision, which is for just administration, you have three elements. Must be lawful, must be reasonable, and must be procedurally fair. When it comes to the reasonableness, you then ask the question, the facts which are in front of me, are they the correct facts in order to lead me to the conclusion of suspending the public protector? If the answer to that is yes, then we must also look at those particular elements. And you can't ignore the element of biasness. Is this going to assist me in any particular matter, maybe in another life in which I would need to answer? Is this going to achieve any other agenda other than the one in which I'm sent to adjudicate on, or maybe that's the correct word, to decide upon as the president? In this case, the court was a bit scathing. I think it's paragraph 157 in terms of saying your motive, Mr. President, is questionable as to whether you took this particular decision based on clear intention, honest intention of protecting the integrity of the office of the public protector, or was it because there are certain questions in which were sent to you and you needed to answer, or was there a High Court ruling which was looming? Maybe you could have thought it was not going to go in your way, and at the end of the day, it dealt with the exact merits of what you were deciding upon. You may have been too fast in making that particular decision. Hence, we are questioning your motive into coming to this particular decision. However, in order for the court to do that, you have to deal with the facts as they are and try and complement and bring them to the reasonable conclusion when it comes to your judgment. So you then have to say, let me look at the elements that are there. Out of my elements, what I've looked at, I can only come to a reasonable conclusion that yes, you are indeed biased. You did not follow the correct procedure, or your motives for taking this decision were not that of protecting the interests or the integrity of the office of the public protector, but were purely on other matters in which I can only assume that they are only there to protect yourself. Another question that came up is around the timing of the suspension itself. I mean, the court raising, suspicions, that's my interpretation, around why the president would suspend Mkhwebane a day before the court was meant to rule on her bid to try to prevent him from doing exactly that. Was the president ill-advised in this case?
I would think so. In fact, if there's another forum which is deciding a matter in which you must take a decision on, it would be wise for you to wait up until that particular forum is decided, especially a forum which is such as important as a court. So it's going to have a material effect on what you need to do at the end of the day. So if it comes back and says, this particular inquiry has not been constituted in a proper manner, it must be started again or something similar to that, then you must come back and say, let me wait up until the court has decided on it, because I do not want to take an improper decision. Let's take the adverse, if the adverse would have occurred. The court comes back and says, no, this committee should not sit, it's not properly constituted. In fact, this whole process is against the constitutional provision, it should start afresh. Meanwhile, you've suspended someone. Then the question is, what are you suspending the public protector from if the committee, which is the sole basis of that particular suspension, is no longer there? Wouldn't you want to wait up until a decision has been made by a court, which is why we go there to settle our differences or our disputes, and then only then make an informed decision. Coming back to your principles or your duties as the president in terms of saying, I need to take a decision which is going to be in the best interest of the office, both my office and the public protector's office, but most importantly, in line with Section 33 of the Constitution that says that every just administrative action must be lawful, reasonable, and procedurally fair. I'm dealing here with the reasonableness. I must be able to come back and say the circumstances and the terms which are sufficed at the time of making that particular decision necessitated that I take this decision in which I've taken, and I can provide evidence and proof as to why is it a prudent one compared to others. If you are going to take a decision when you are not really informed, then you're going to have a problem at the end of the day. So the court was correct in saying, Mr. President, maybe you should have waited up until you have pronounced on this matter, and then you can move on.
In fact, that criticism emerged the moment that suspension made headlines, because it did seem suspect, at least from a distance. Mpumelelo Zikalala, thanks as always for helping us connect the dots on issues sometimes that tend to get very complex.